We call our podcast the four, or Beyond I Do, the 411 and all things Texas family law.
Here we go.
Yeah.
Well,
So I don't know if it's that or if it's the Matt Kersling show.
no, we're gonna stick with yours, and the reason why I want to do it is because I feel like there's a lot of information out there that people already have about the lending and about the real estate side, so we can kick it off on the divorce side because I think a lot of people have preconceived notions about the way that it works, and then all of a sudden they talk to the professionals and find out that it's
not that way.
It's not that way. And I see it on both sides, right? I see it with people who think it's going to be like something crazy, knock down, drag out, and there are going to be all these things that need to happen. And then I see other people that think it's, no big deal. Like, oh, I just sign a quick claim and then I'm done with this house, right? So I think that, going around the table and introducing, I mean, the very first thing, we have a new guest here. Jimmy and I have done this quite some time. But Liz Warren? Liz Warren with Modus, which that's new.
It is,
Let's talk about that.
Yeah, so Modus Real Estate just got started in Austin in the last year. It was founded in Denver in 2014. We've got a great development arm there. And then we're just getting started here in the Austin area. We've got a number of agents now, but we're probably getting close to 40 agents.
I hear you've got a really cool office over there on Barton Springs Road.
Yeah, we're already outgrowing it though. But it's been a really fun switch to be kind of part of a startup in the real estate world, kind of approaching things a little bit less. It's not a big brokerage. It's not a big Wall Street
like more
firm.
boutique.
Yeah, more boutique, more startup.
How many trips to Terry Black's get made?
A lot.
I would envision.
That place is always busy.
It's
and
good.
It's legit. It's good.
Yeah, and Carpenter Hall right there for coffee. That's sort of where we do a lot of our off-site meetings.
Well, I overheard that you said you have a place in Lockhart, and that there's good barbecue out there also.
I was just down there the other day, and I was there at breakfast time, so I missed the barbecue. So every time I go back, I prefer Terry Black's to regular Black's, but
same.
Yeah, it might be fighting words.
No, I'm with you. I agree.
So when we talk about the whole lending versus real estate versus divorce, I want to go around the table and kind of get a consensus on who do you think gets the first phone call when they're thinking about splitting up? Is it the real estate agent? I need to buy a new house and get out of this place. Is it the lender? I need to buy a new house. Can I afford it? Or is it the real estate agent, or excuse me, the divorce attorney, where they're like, hey, we're thinking about splitting up. Am I allowed to leave? Or what are the repercussions if I do so? So what are your thoughts? Do you feel like you're getting the call, or I'm getting the call?
I think it depends on how contentious it is.
Okay.
I was fixing to say the exact same thing. Yeah.
I typically feel like I get the call first. I really do. I find myself in a position to where people want to know financially what's doable, what is not. However, the calls that I don't get, or that I get too late, are the ones where you've got individuals that know they can purchase homes without the other party, and then they just go and do it and don't consult anybody. And then, like I said when we started this, I always find I signed off on the title, so I have no
say so.
Not even say so, but I have no potential repercussions if this or that happens, and that from a lending standpoint couldn't be further from the truth. And that's the one thing that Jimmy and I have talked about on the podcast before is if you've got a loan and you're financially responsible for it, you definitely want to make sure that you either very much so trust the person that you are about to divorce, or you want to make sure that you relinquish yourself of those financial obligations. And that is not just by signing the title of a property and signing away on it.
Yeah, and those initial questions depend on, because every one of us are offering different pieces of information, and not one's any less important than the other, because, calling you is a very common thing for people trying to figure out if they can refinance and buy their, their spouse out of the house, or if it's even doable, possible, based on income and or the outcome of the possible divorce. Calling you typically is what can we sell for, or what's the value, or what's the damage, or how much has it been reduced, or whatever. But
or
determining,
are we gonna be stuck in this house together forever?
Right, determining value and can we sell? Like how is the market and how is it really doing? And then of course we're the divorce side of it, where we sort of incorporate all of that if we can, and where things are by agreement, we certainly can do that.
Yeah, that's true. I mean, and again, the agreement as far as I gotta stop and say agreement as far as, hey, I'm going to make sure I make this payment and I'll eventually refinance. I unfortunately have seen it more times than I would like to admit, where somebody either misses a payment or just intentionally. I've seen that happen too. I couldn't prove it, but it seemed pretty darn intentional. Somebody intentionally misses a payment, and now
The other person's on the
hypothetically
hook.
you're trying to buy a house and I'm telling you, well, there's a late payment on a mortgage here. Like, oh, well, that's it has nothing to do with me, and I've got a divorce decree to prove it. It's like, we literally don't care. We legitimately do not care if that late payment is on your credit. That's a problem. We can eliminate the liability as an expense as far as debt to income ratio is concerned with the divorce decree, but if there's a late, you're going to get dinged for that for sure.
So, do you want to address that topic, or which way do you guys want to go?
Yeah, I mean, let's roll with that, and we'll keep it going. I mean,
Because the scenario that you're describing is in a divorce, and typically it's an agreed divorce, because when parties are not in agreement, Liz, you probably get this after the fact when the parties are ordered to sell the house.
Right.
But I always say that the only ways out of marriage is you got to die or by agreement, or you got to go to court, and we don't want you to die. And if you can't reach agreement, then you've got to go to court.
Yeah.
And the judge's limitations are to either award that real estate to one or the other spouse, subject to that debt, and then the debt gets ordered one way or the other, or it's ordered sold. And so the court does not have the option that you're talking about, where they can order somebody under the law to refinance or remove that other spouse, like within a year you have to refinance or whatever. That can only be done by agreement. So if parties are reaching the terms of agreement and negotiating their house, and somebody has talked to you about valuation and talked to you and gotten pre-qualified to take $250,000 in equity and buy their spouse out, that doesn't necessarily mean, right, that they have washed the other spouse of that debt.
Right.
And so what the spouse has to watch out for, that's being bought out for or being bought out of that equity, is that liability on that note.
Right.
And as a young family law attorney, I'm not sure. Honestly, I was really that cognizant of that issue. I mean, but obviously, the more experience you get, you're very aware of that, because first time somebody comes in with that very problem. And you have a divorce decree that says, well, my ex-wife is supposed to pay the mortgage, and you look at that divorce decree to see what you can enforce, like take to court to do something about it, and there's nothing in there about refinancing or selling the house or whatever. If you don't have terms in that divorce decree that address those issues, you're just, can we use the word screwed? I mean, you're just
I've
screwed.
seen it. I mean, at least for 12 months, and that's usually and don't get me wrong, we could talk about loan programs where if you have a late payment, because you should read some of these comments. We've gotten awfully popular, and sometimes people just want to eat my lunch. It's like, listen, there are programs out there where you could buy a home with a late payment, but trust me, you're not going to enjoy the terms and conditions that are associated with it. But just moving on past that, it's like, it's those late payments, and furthermore, what about your credit?
Yeah.
So absolutely want to make sure that you have all of that in writing and all of those things. But even if it is in writing, I mean, here's a hypothetical, and I know what your response will be. You'll say, well, we'll have that buttoned up front.
Yeah, it has to be in the decree.
But I've seen a lot of decrees that aren't buttoned up like this, where, and I'd be interested to get your take on this, where, let's say you have 90 days to refinance, right? I'm, getting divorced from my ex-wife. She's taking the property. I don't even want to buy out. I just want my name off the loan. I want to relinquish any responsibility, not only of ownership, but of liability on the mortgage. So if she has 90 days to do it and refinance, if on day 60 she misses a payment, to your point, I'm screwed.
Yeah, and so if the divorce decree covers those terms, right, that you have that contingency not only has she failed to timely refinance, but she's also not followed the terms of the note
Yep.
and not timely paid or not cured in a timely fashion or whatever, then the following things can happen. If the divorce decree covers that, and usually ours will, at least if they want those terms, it depends on what side I'm on,
Sure.
you know.
I like there has to be repercussions.
But if there's repercussions, for example, that triggers a for sale, like an immediate for sale, and then what I usually do, because I've learned the hard way, because in previous years I've seen decrees that didn't do this, so I usually try to write in the whole for sale provision. You know, here's what triggers the for sale. Here's how you select the realtor. You know, if they don't list Liz Warren, you know, by name, for example, then I might say that one person picks 3 names and the other person just picks one from those 3. But there's a whole process, you know, so that someone who's the aggrieved party, right, that because that payment's not being made or it hasn't been refinanced, can go in and actually enforce that. And the ultimate protection, but this is rare, is to put in what's called a receiver as the backup. Right.
Okay.
So the receiver is like the last option you want, because that's like taking a Liz Warren or a Matt Kersling out in the real estate market and hiring you to come take over the property, and you know, and you take it away from the parties, and then you just go complete the sale. And the parties, I mean, they have input as much as you want to give it, but then you have total control over it. But then you're getting paid some kind of a fee. It can be a commission. That's debatable, because the commission gives you an incentive in the pricing. But typically it's at least an hourly rate or it's a flat rate or something. But the point is the same, is that if you're the one on the side that's on the other side of your spouse being required to refinance or make those payments, especially the longer that period of time is, you want those protections in place. And it's got to be in the divorce decree. If it's not, there's just not much you can do. There's nothing you can do.
Well, and I would tell anybody, too, if you're on the loan, then you have access to it, so you should definitely keep an eye on it.
Yeah.
I mean, you know, it's a shame. I like I said, I see it. I'd say I see it almost at least every other year.
Yeah.
I've been doing this a while, so I could think of, you know, probably 8 to 10 people in my career who have gone to purchase a home. We pull the credit. There's a late payment on the mortgage, and they're like, "What are you talking about?" They don't even know.
And what even your late payment?
Right.
That's the problem. Yeah.
What kind of divorce situations do you find yourself in as a real estate agent?
I've actually had a few where there's one just a couple months ago where they're in the process of the divorce. They don't have the decree yet. They haven't even finished mediation or finished kind of deciding what's going to happen. And one partner's like, I'm going to go find my own place. Being that it's a community property state and they're still legally married, getting that one partner to say, this is mine, I'm buying it by myself, getting the other partner to agree, not have any ownership of that, and making sure that that's all coordinated before it takes place, because maybe it's the partner's just done. I just want out. I just want my own spot.
Yeah.
But it's not cut and dried yet. Like what are the arrangements that they have to have? What do they legally have to have written from their lawyer? What do they have to provide to title to say, I am owning this property by myself?
What trumps community property?
Well,
while
separate
while
property,
legally married.
Well, so the answer to that is because it's not that uncommon, because we do so many agreed divorces in our office where people are working very well together, and one spouse, and they've got enough money that somebody wants to take their community money and go buy another house. But there are what are called standing orders in all of our counties, Travis, Williamson, Bastrop, Hayes, that technically prohibits that, to go and incur debt to go buy something like that. The exceptions are very narrow in terms of what you can incur debt for. You can incur debt for paying attorney's fees. We make the list, and reasonable and necessary living expenses. So the question would be, buying a house, is that a reasonable and necessary living expense? And most of the time, the court's going to say no, if that's not agreed to. If it's agreed to, the answer that I've done, and it's kind of a creative workaround, is to get the parties to agree to an order that modifies, say, Travis County, the Travis County standing orders. And it goes through and basically just lays out those terms that they're in the process of a divorce, agreed divorce. They've all agreed to X, and that this person can use community funds, you know, to draw from to purchase this house. And then they can go as far as, if they want, depending on the level of agreement they have, to go ahead and partition that asset and make that the separate property of the other spouse by court order and by agreement. And then you have a court order saying that person can go incur that debt, can use community funds, and then you typically in that order we will address those community funds, meaning they're awarded to that person in the final decree. So in my experience, when we get that order signed, they have no problems while a divorce is pending, getting closing on a new house.
So before everybody out there gets too excited, the first part is it has to be agreed. Which
Has to be
I
agreed.
usually,
Right. Yeah.
I've definitely seen that happen, and we've never even had to have anything technically drafted, although it's absolutely best practices. However, the next issue that you can run into is the other attorney, because there's typically always an attorney involved at a title company. They're going to be very direct in saying, hey, like, we know that you have this order involved, but just for the record, like, your spouse, for example, because you can buy in Texas and your spouse doesn't have to be there, but you can't sell, correct?
I'm not sure I would agree with that one because we're a community property state. So what I've heard more often than not, like without an order like what I just described, they require the other spouse to sign something.
Yeah.
And most of
The
them won't.
mortgage.
And most of them won't even close. I
Right.
mean, if the other spouse just gets nervous and
Exactly.
says, I didn't. It's his. I'm not. I don't want to have anything to do with that.
Well, and so that's
You know.
kind of my point. Unless it's agreed,
Yeah.
good luck.
Now
Because
here's
we
the
run into that all the time.
But even if there's not a mortgage, let's say, like if one partner is going to buy a house, they can qualify on their own. They don't necessarily have to have their soon-to-be ex-spouse.
See, now we need the title
on-
attorney in here.
Right.
Yeah,
on the
because
loan.
it's still presumptively community property if
Right.
they're buying during
Regardless
marriage.
of
Yeah.
who's on the note, they're both presumptively going to be on title if they're married and it's community property state without that specification.
That's where we run into the issue as a lender. Like, we'll lend people money. We really don't care.
Yeah.
Right?
Right,
We're
they
not like, oh, you're
qualify.
married, you're not married. It's title won't insure the title in those instances if they can't get the soon-to-be ex-husband or wife to at least sign off an acknowledgement that this purchase is happening.
Yeah, and that's why I typically advise people if they're working together to get that agreed order. It's overkill, but it's worked. I have not had someone not be able to close or purchase using that order. I've probably done that maybe 14 or 15 times. I mean, not a lot, but that's a lot. I guess.
The order,
Yeah.
absolutely. My point is I have definitely had situations. We just had this happen in October. We had a deal at the closing table. I was on the buy side, and it was a divorce situation, the sellers, and, the wife had said, yes, I'm going to sign off, like, we're good to go, everything's fine. We got to the day of closing, and I don't know what he did or said in the last week, but she basically was like, nope, I'm not signing off anymore. I want to make sure the divorce is finalized. And my buyers were like, what the hell is going on? Like, we're closing today. We're clear to close on the loan. Title's good with everything. And
That's a mess.
it's a
Right.
total mess.
Because now you've got breach of contracts and all kinds of situations.
Exactly.
So
They can sue for specific performance at that point.
They
and
did.
then-
They
yeah.
did.
Yeah.
Yep. So it was messy for sure.
well, and it's a very unique circumstance, but I've had it happen 3 times where parties made some kind of an agreement like that. We'll just call it did a significant transaction. One of them was the purchase of a home during the pendency of the divorce, and everybody. Back then, it wasn't done as an order. It was done as just a written agreement, what we call in my world a Rule 11 agreement, which is just kind of a contract. But the problem was they sat on things for a while trying to just work things out, and the divorce never got finalized, and then the whole thing went south. And so what was agreed to became very contested, and we had almost 2 years worth of them living under these terms. But it was just this civil agreement, this Rule 11 agreement, so it wasn't a court order, so it all got revoked, and it just created this massive mess. So that's something for our listeners, to be thinking about. Sometimes the court order is the right way to go, but if things go south, you need to assess the risk with your attorney, even if it's an agreed divorce, as to what could happen. But if everybody's super transparent, working together, that agreed order is the way to do it.
I wish everybody was super transparent and working together.
It happens.
My life
happens,
would be
yeah.
so much easier.
Yeah.
I'm sure you
Yeah.
could say the same.
100%.
What other pain points do we run into, between the three of us? I mean, you've got 3 major facets, and title would be another one. But, what other pain points are you seeing? I would envision on the real estate side, there's a few others you can cover.
Well, I think having everything in writing is always smart, whether you're married or not. If you're buying
Agreed.
a house with someone, whether it's a prenuptial or it's some sort of agreement, make sure you know that,
Totally.
you've got that outlined, what happens if things do go south, and what are you going to do with the property in the event of
I'm seeing more common of people buying homes together prior to marriage. Are you seeing that?
a lot,
Yeah.
yes, yeah. And oftentimes one partner is the borrower
Yeah.
and
And
not
the other puts down money.
right?
Yeah.
Or isn't even on the note at all, and they're taking title together.
No, that's not true.
I was about to say that's not how I always see it.
It's not about always seeing it. It's just that we will not accept funds as down payment funds from a non-direct family member if he or she does not go on title. So in a situation where you've got like boyfriend and girlfriend, boyfriend's buying the house, girlfriend's putting money down, they could work things out on the back end that we don't know about. But hypothetically, if we can't source it, so
Not counting it as a gift or down payment. So
you
just
can't
be,
even do.
right.
You have a tough time doing a gift from like boyfriend to
So
girlfriend.
that's what I'm saying. They're both on the title for the home.
That's usually what I'll see.
right.
So
and only
like
one is qualifying and on
correct.
the note.
Right. So you yes. So you have one that's financially, responsible. Another one is not, is off the hook. It's a great place to be.
Right. So if they split, the non-borrowing partner could claim
Right.
ownership of the home.
Absolutely.
So having that in
Absolutely.
writing
No, they
on the front end.
they can't claim. They have
Right.
ownership of the home. They've succeeded there, and yeah. But if they are going to put money down, and we can't prove that the other individual has enough money with or without him or her, that person has to go on the title.
Well, I've recently seen a situation where they were getting married, and the now wife, because we're going through divorce, put down about $180,000 on the house, but they required a gift letter because back then they were just dating, and she did not go on title. So how common is that?
So gift letters, I mean, we have to show like a pretty common type bond thing. I mean, I've gotten them done with fiance. So like this is one of the things I see a lot, which is just kind of funny you brought this up. I definitely see situations where, just like we talked about, it's like, oh, we're getting married, right? And people think if they just say that, then it's good to go, because guideline specifically states that gift funds have to be from a direct family member. And they've even opened it up over the last few years. I mean, it used to just be like mom, dad, aunt, uncle, grandma, grandpa, brother.
Really? I didn't even realize
brother,
that.
sister. Oh yeah,
okay.
it's a written guideline. Now they've opened it up to step parents. That's one that we're allowed to do is step parents now. And then things like fiance, and then if we can show some sort of like long-term relationship, like almost like what do they call that? Domestic partnership.
Mm-hmm.
We can do that as well. But they're very difficult because, and this is what gets frustrating for people, there's bad guys out there, right? And a lot of times I know my clients aren't trying to be bad guys, but they're out there. And so when, you've been together with somebody for maybe a year or two, but you haven't lived together, and, you're not married and you're not engaged, and you're giving these gift funds, and it's very difficult to track any sort of like actual relationship, that right there is exactly what someone would do if they were trying to like go in with an investor. And Jimmy and I just decided that, now we're gay lovers and we're going to buy a house together. Right? Like there's people out there that do that.
I do love you, by the way.
Love you too, brother. And so, I do have this happens a lot where people are like, well, we're getting engaged. And the very first thing that underwriting will request, and this isn't the only thing that will kind of like make it go away, but the very first thing we'll request is proof of purchase of an engagement ring. Because, and I think you can probably tell me this, when you purchase an engagement ring, it's typically listed as an engagement ring. They will ask you, are you purchasing this as an engagement ring? Because I know in my divorce, for example, they had asked for it to show proof because I had purchased a fairly expensive engagement ring and wedding ring that I was, basically in the divorce not getting back. And I said, well, there's value in that, right? And so was it an engagement ring or was it a gift?
It's a gift.
And so, I mean, my jeweler had written it as an engagement ring, and it was like, okay, this was for the engagement of the marriage. And, it was
still a gift.
It was quickly, correct.
I kept mine.
But there was, so we do, as a lender, we require, that's the first thing that will make this go away. It's like, send us a receipt of your engagement ring.
But you're speaking for potential engaged couple where they're both going on
That
the
is
loan,
when we
or
can
that's just
easily,
if
that's when
one
we can use the
person's,
gift funds, is what I'm trying to say. So
but
this is
not
a
necessarily,
non-related.
the gifter is not necessarily going on the qualification for the loan. They're just contributing
Correct.
towards
Correct.
the nut of down payment or whatever.
So
That's
in
right.
that scenario, if they can't prove the long-standing relationship, but they're not going on title, what happens? Can you just do a gift
No,
letter?
I mean, if they're not going on title and we can't produce anything that would allow us to justify a gift letter, then we can't use those funds, period. So it's unusual that that happens, but I mean, these are for like
Even with a gift letter?
these are these are for like straw buyers and stuff like that.
Yeah.
Like, as an example, what someone would do if they were a bad guy. So you and I decide to, tell a lender again that we're in a relationship and we're moving in together and we love each other and we're getting engaged. What we might actually be doing is trying to purchase a primary residency under my name because I don't own a home yet, and you're coming in as an investor, and we're going to buy this home together. We're going to fix it, we're going to flip it, and we're going to split the money. That's not okay. It's not okay. Can't do that. So we would have to purchase it as an investment property, and then even then, here's another fun fact that gums everything up. So if you and I were like, okay, well, we're going to do it the right way, we'll purchase it as an investment property. Now we have to put down 15%, right? So we can't do the low down payment because we can't treat it as one of our primary residencies. And then even if you want to give me money, but let's say maybe you don't want to go on title because you're in the middle of a divorce, right?
Yeah.
You can see that happening.
Yeah.
You're trying to hide an asset now. Well, guess what? You have to go on title because gift funds aren't acceptable in the purchase of an investment property. So there's all these things, and they're all designed at the end to like do the right thing. Because you just put me on that. The whole divorce thing could be anything. Like, I don't want to go on title. I don't want to. Why? Why would you not want to go on title of a property?
Well, so for those listening, right, back to sort of the,
the bad guys out there.
Well, the relationship, right, and to protect yourself, like if your potential spouse is talking about no worries, just do the gift letter and let's just move on. And let's say you have a lender who's willing to do it. I mean, all that information
they're out there
is a major red flag because I'm dealing with a divorce case right now that's exactly what happened. It was back in 2012, but that's exactly what's happening right now. So it is very important, like what Liz is saying, is you need to have an agreement, whether it's a premarital agreement or a contractual agreement or domestic partnership agreement of some sort that addresses that. It can even be like a partnership agreement or joint venture or put it in an LLC, if it's an investment property.
Yeah, but remember, if you're signing it as a gift, it's a gift.
Well, but I'm saying people can address that on the backside, right? Like in a prenuptial agreement, if they actually do end up getting married, that's the keys. You have to get married for the prenup to actually take effect.
Right.
But on the backside, let's say they get married 6 months later, they did the gift letter or whatever, a prenuptial agreement can recapture that and give them the interest back or give a claim for what's called reimbursement back for that 100,000 gift funds that they put down.
But gift funds are a gift.
Yeah, but
and the letter explicitly states, I do not require repayment.
Right, but that's for lending and tax purposes.
Right.
That's not for divorce and domestic, law purposes. And so we can, in the prenuptial agreement, write around that and just acknowledge that, yes, that was a gift, but the parties intend for this to be reimbursed, and then we can actually write a reimbursement claim back in on the backside.
Interesting.
It's not as probably as enforceable if you don't get married and it's a prenuptial agreement, because a prenuptial agreement actually goes into the divorce court and can be dealt with. Another surprise factor is in a prenuptial agreement, because when the house is bought before marriage, we all know in Texas that's what's called your separate property, right? And separate property cannot be divided between the parties. But if you do a prenuptial agreement, let's say even under our scenario, girlfriend, fiance puts $100,000 in, puts a gift letter, whatever, and it's clearly that person, the other spouse's or fiance's separate property. But a prenuptial agreement can actually do what we call convert or commute that separate property into community property. So once they get married, there's actually language in Chapter 4 of our family code and parts of the Constitution that can actually take that house, and that is clearly that person's separate property through the gift funds or whatever, and commute it to a community property asset that now makes it divisible in divorce and owned half and half.
And is that recorded like as a deed?
You can
change?
record it in the deed records.
Mm-hmm.
Most people don't because the prenuptial agreements are typically private,
Mm-hmm.
and depending on the terms that you have in there, because I have people who, in their divorce decrees, for example, I had a couple recently that the husband is a realtor and they were selling their house and they wanted to write in all these specific terms, right? Like the house is going to be 2% as the commission. This is the listing price initially.
Right.
And if it doesn't sell within 21 days, it gets lowered to X, and 21 days lowered to X. And I tried to tell him I wouldn't do that because this is a public document.
Mm-hmm.
And, people out there may find this and realize if they just sit you out for
wait.
2 months and wait, that the price is going
That's
to
a good
keep
point.
coming down. So it's the same thing. Now there's a way around that. We can talk about that, but that's how we did it. But a prenuptial agreement in that scenario, if parties are in agreement, right? I mean, can actually take that separate property asset. So if that's a way to get somebody the house and use the gift funds to do it because one party has bad credit but gets money from a parent or inheritance and the other one has the credit, you can buy the house, that's your separate property, but then you want to do that prenuptial agreement that can commute it to community property or can write back the reimbursement and recapture that. The hits, of course, is you got to get married.
So then
You know,
at time
for that
of
agreement
purchase is
to-
just one person on title?
If under
that?
the scenario we were talking
Okay.
about.
And
Well,
then
in
if-
this scenario, because I don't want to get lost in this. What happens in the event that we claw back the gift funds, right, through going around the gift letter that this party explicitly signed and said, this is a gift, I do not expect repayment. We claw back that money. The buyer has to pay back said, in this instance, the $108,000. And now the person who just paid that 108 goes into foreclosure court because he or she can no longer make on-time payments because of the $108,000 that was clawed back. And when they're standing in front of a judge and stating, why would you foreclose on this property? It says, well, I received a gift from Martha Smith for $108,000. She said she didn't expect any repayment. Here it is. We closed on the property, and somehow her attorney clawed back $108,000, and I can't make the mortgage payment anymore, and therefore that's why I'm foreclosing.
I've never had that happen. But because usually
Because that's why those gift letters exist. They're
Yeah.
the CYA for us.
no, clearly.
So that when, someone's like, I can't make these payments anymore, we're like, well, why? And they're like, I had to pay back that gift fund money. And it's
Yeah.
like, that's literally what a gift letter states is
Yeah.
that is not a reason for you to be able to foreclose because you don't have to pay back that gift
But again,
fund.
the scenario we're talking about is people are working together, and
Sure.
yeah. And so, but I've never had that happen. But I've only done what we're talking about maybe twice, so it's
Right.
extremely
Pretty rare.
rare. And I do, 30 prenuptial agreements a year. I mean, at least.
I swear
so,
on the money
yeah.
side of things, people get so creative and they
Sneaky.
don't go through with it most of the time.
And by
but
the
I
way,
get asked these questions.
And by the way, the I think to make sure we're clear, they don't necessarily write that they're clawing back the agreement, right? The gift. I mean, when we write the prenuptial agreement, they can write a term that just says that spouse is entitled to
Sure.
$100,000 and it's a community asset. I mean, it doesn't necessarily mean they're clawing back the
That's
gift.
true.
In
And you
of
can always
itself.
sell.
Yeah, it's a term of divorce, not necessarily clawing
So
back
to
the
your point,
gift.
you got to get married.
Yeah, but you got to get married. If the person changes their mind, that would be a valid defense, maybe,
Yeah.
or something to
That's a
try to
good
deal
point.
with that.
You got to get married. Then it is community property. Then none of it matters.
Yeah.
Right.
There, we
Yeah.
figured it out. I love these conversations.
For the 2 times that it happens in
Right.
a whole
Hey,
career.
those are the ones that are the most
They're the
exciting.
ones you remember.
That's exactly right.
It's true.
Okay, other hot topics that you're seeing.
Gosh. I think with divorce, figuring out where you get to live next because of geographic restrictions that might come up, and couples deciding, okay, we're going to sell the house, and then we want to rebuy a house, but we can't afford to buy a house in this area that's dictated in our geographic restrictions.
That's interesting.
So that definitely limits where people can go. I've seen that one come up a number of times.
Yeah, geographic restrictions is probably a whole nother topic. I don't know if that's, but they're very common.
Mm-hmm.
And again, if people are in agreement, you can be as creative as you want on those geographic restrictions. But court-ordered geographic restrictions are typically pretty broad. you
Right,
know,
school
um,
district or
yeah.
county
Yeah, and
So
the
this
short
is
end
people
of it
can't
is
leave or they have to leave.
cannot
No,
leave due
yeah.
to
Got it.
co-parenting. They are
Right.
required to
That
stay
makes
within the
sense.
same
Yeah, I call
school
it
district.
a
Or,
goose and gander rule where the primary parent's required, as long as the non-primary parent lives in that boundary, to stay in that boundary, because it's designed to protect the relationship with the non-primary parent and the kids, so that the primary parent can't just up and move to Canada,
Right.
right? You know, and but if the non-primary parent moves to Canada, then the primary parent's free to go anywhere about the country, kind of a thing. So
Gotcha.
I don't know how we veered off on that.
yeah, no, I've seen it a couple of times where, let's just say that the family has had their family home in Circle C. They split up. Mom wants to stay in Circle C because her kids go to Bowie High or, Kiker, whatever it is. They want to stay in that area. She, as a single parent now, can't afford to stay in that area. And just because, maybe she'll be forced to rent, but she's trying to maintain the same kind of lifestyle that her kids were used to, keep them in the same boundaries with their friends. Because things in the Austin area aren't necessarily as affordable as they might have been when she bought that house as
Right.
part of her marital
Yeah.
home. I've seen that a lot where, custodial parent or not, they're just forced to go move elsewhere.
Yeah.
And affordability is a big issue right now.
That's true. Fortunately, that part I don't get to deal with.
Yeah.
Actually, that's not true. I have to say no. I have to say no. You can't. You can't afford this, or you can't live there. And yeah, I mean, how does that work?
Well, the term lifestyles might as well be the F word in
Right.
divorce, because divorce is, unless people are extremely wealthy and they're dividing, multiple seven figures, it's which happens, and we deal with a lot more of those than probably a lot of firms, but it's still rare. But lifestyle is not something that is typically in California. Like, for example, that is a standard when they're dividing assets and calculating financial support or alimony. Standard of living is actually factored in. In Texas, it's not.
Interesting.
Yeah, and so we can go into a much deeper
But just
discussion,
'cause
but
we're not all celebrities here.
well, it's just not part of our law. It's and so alimony, for example, is basic. Its basic idea is to help the qualifying spouse for whatever those reasons are to meet that spouse's minimum financial needs, right? Not lifestyle,
Right.
for whatever period of time the court orders, depending on the circumstances. The only thing closest to lifestyle would be if you have like a truly disabled child and you're trying to keep and continue meeting that child's life needs. That'd probably be the closest I could get. Or again, really wealthy families that have really high wage and income. Then you can see the $20,000, $30,000, $40,000 monthly support kind of things, but that's rare. Yeah.
That is one thing I get to see a lot of is, I hear on a, not even semi, like on a regular basis, one of the lines is, hey, we're going to look at your credit. We'll figure out what we can put together as a budget. And they go, my credit used to be 800, but then I got divorced. And it's always interesting to me because, as the money guy who looks at this all the time, it's like you had dual income, obviously a lifestyle, and there's going to be change, right? There just is. And it's always interesting to me because I can see just through the data. I don't obviously get to see the emotion and the things that happened. And I've been divorced too. I know how that goes, but I can see through the data when those situations occur. It is very rare that I see a situation where somebody got, like screwed, if you will. It's usually someone's trying to maintain a particular type of lifestyle that they were used to with the dual income. And two incomes is always going to be better than one.
Sure.
And it's one of those things that I just don't think people think about, because there's a lot of emotion involved and there's a lot going on. They're talking to attorneys, they're thinking about moving, but it's like, are you ready to change your financial lifestyle? And I think that's the last thing people think about.
Yeah.
And I see a lot of that in the divorce thing. And then it's like, now I'm, now I have a 600 credit score and here's this and here's that. And it's like, where did all this money go? Because it's your credit card, right? Like it's your money. But yeah, it's tough. And I would the both of you have to deal with a lot more of that than I do. I just get to see the data and how we're just emotional creatures.
But the debt is also a community property, right? Like,
Yeah, and
if
and
they,
it's rare, but I've seen courts where let's say the wife is ordered to award the house to her, and the husband can be ordered to pay the mortgage because it's a community debt. And that's really rare. I've had that happen maybe twice where maybe people weren't married and it was ordered as child support. That's is exceedingly rare, but that can be done too. So. What would you say if people are getting ready and having the conversation and they're about to bring a realtor in, but they're contemplating divorce? What would they need to be doing?
well, I think it's really important to have a neutral party as the realtor. If I'm friends with, one of the partners, I don't necessarily want to be the realtor involved.
For the sale.
For the sale,
Yeah.
right? I'm talking for the sale. There's a lot of agents out there. Everyone knows probably 12, 13, 15 agents, but maybe don't use the one that you purchased with. Maybe
Yeah.
pick a neutral third party. I have kind of a unique perspective in that I actually have a master's degree in counseling psychology
wow.
with an emphasis on couple and family therapy, but the cobbler's kids don't always have shoes, and so I've been divorced and split all this up. But I have the experience of working with couples in a therapeutic setting, and I think that's helpful in mediating sort of a neutrality with couples who are divorcing and helping calm the emotions because it is fraught up and down. I mean, buying a home even in the best of circumstances or selling a home in the best circumstances is still emotional roller coaster.
Absolutely.
So part of my job is just to help diffuse that situation and be the broker, be the arbiter of peace between them, just saying, okay, this is what we're doing to get this job done. Also, get everything in writing. I've seen too many times where we see one partner say something on a phone call and the other one feels like they were misheard or they didn't get their fair shake or it was one
Yeah.
person taking sides. So when I'm working with couples, I'm just like, look, I'm not your realtor or your realtor. I'm the community, the partner's realtor. I'm here to help you guys get to the closing table. And I'm not arguing in court like Jimmy has to do.
Right.
I'm just helping them get beyond this chapter so that they can kind of see the finish line and get to whatever the next step is.
And
Boy.
I always tell people to be transparent, because that's one of the quickest violations that I see is somebody goes out and grabs a realtor and signs a listing agreement and says, "Here, sign this." And because they're already contemplating divorce, and then all of a sudden, and maybe it's their friend that or that they bought
Right.
the house with or something, and that just immediately creates mistrust in that person. And that I've heard 1,000 times how people think somehow that realtor is going to do a backdoor cooking of the deal and the commissions. And I mean, is that even possible? Because people, that's like a real
No,
issue.
if there are two owners,
Title will shut that
right?
down.
If there are two owners on the property, they both have to sign everything. They both have to be in agreement on what the listing agreement looks like, what the commission's going to be like, how it's going to be marketed. I mean, I can't just take one partner and run with what they say.
That's legitimately what happened on the deal that I described where my buyers were at closing. So the real estate agent was a new agent. I actually talked to him because for a minute there, when we were at the closing table, I pretty much contacted the listing agent, was about to flip out. Like, what are you doing? It was totally unprofessional, but I realized he just wasn't very experienced. And he had this buyer convince him that, because he had purchased the property before they had gotten married, that there was no reason why she needed to be there. And then when title was pulled, title connected with them and said, no, she does need to be here. And so the buyer turned around and said, okay, she will be. And then when she wasn't, for all we know, because everything was going through, we title was unable to connect with her.
And she was in the dark the whole.
No, she knew the entire time about the sale of the property, but I am speculating that she was never going to sign. And I think that the seller was under the impression that like maybe it was just going to close. I don't know.
Yeah.
And finally the day came, and
If he had a court order,
we did not close, and they
Yeah.
walked away from that house and bought a different property, and there's lawsuits and all this other stuff.
yeah, that's another. When people are, because in Texas on an interim basis while the case is pending, you can't force the sale of a homestead anyway. But you can order the sale of a homestead on a final order or the final trial. So that's a circumstance if divorce is pending and people are trying to sell their house one of the things I'll encourage them to do for that reason is to get an agreed temporary order for the sale of the house, to cover all of those terms, including what happens if somebody doesn't, refuses to come to the table and sign the documents, because that way the other spouse is court ordered to sign those documents
Right.
and to sign the listing agreements and sign the closing documents and all that. And if for some reason you end up in that scenario, you could at least pause for a day or something and go get emergency orders and maybe try to force that person to sign off. But without temporary orders, assuming a divorce was happening, then, you can't do it.
Yeah, and as a realtor, I'm going to ask if someone's coming to me and they say, we're splitting up, we're needing to sell our house. I want to know where they are in the process. Have you
Sure.
talked with an attorney? Have you already agreed on what the process is going to be like? Who is, where is the house going to go? Who has decision-making power if it's already gotten to orders?
Yeah, because you'll see the red flags right away.
And for our audience, I mean, there's no world where, kind of to your point, if, my wife and I live in Circle C and, I've been a stay-at-home dad for 5 years and now she wants to leave me and I want to keep our kids in Circle C because they've got friends and they've got all of these things. And, we go through the financials and there's just absolutely no way that I can afford this house on my own. There's no world where I can just say, well,
Too bad.
come and get it, come and take it, right? I mean, you're saying what that would be is that eventually there would be some sort of court order to either sell or to refinance. I mean,
Yeah.
Right.
Yeah.
That's just for our audience. I mean,
Yeah, no, otherwise, yeah,
You're gonna
exactly.
go into foreclosure and then
Right. No, I mean, I get it. I just,
And there are
definitely.
times when that's part of the strategy. I mean, when, I can sort of reveal here. I mean, sometimes financial chaos is what I call it. And that's our code word, and that's our code for that strategy in our office is the way to approach the case.
Sure.
If let's just give the extreme example where if both spouses are unemployed, find themselves unemployed and can't, go find and regain employment. But let's say it was the husband before that was the primary wage earner and was paying the mortgage, but you can't pay it. Sometimes the strategy is maybe not necessarily find that job, and
Right.
and then they start worrying about their credit, and I'm like, well, I can't fix that one. Well, and then the property taxes come due. I'm like, well, I can't fix that one either, but they're gonna get paid, but it's not gonna get sold unless she agrees, or we go get a court order, which won't happen for a year from now. So, but if it gets foreclosed on,
The things I've learned on this podcast,
you know,
because what I know is I'm very much in love and I'm not going anywhere in my current relationship. But if I do, I'm going to marry a woman with storage facilities.
exactly, yeah.
the
You-
longest closing, like sitting at a table, the longest closing experience I ever had was over 4 hours, and it was because the husband brought divorce papers to the wife at the table.
Wow,
Yeah,
that's not cool.
no,
I don't know. What did she do?
Yeah,
she refused to sign.
No, I mean, that
Yeah.
would cause him to do that.
Yep, she refused to sign, and we
Oof.
sat there until we could figure it out.
well, there you go.
That sounds terrifying to me. I would not want to be in that room. So
That's bad timing.
we have to know, how did it end?
She ended up signing.
Okay.
Yeah, because she wanted the money from the sale.
Yeah,
of course.
she wasn't going to get anything if, they were selling the house, and then she just didn't know that the divorce papers were coming at the closing table.
So she did it for the money.
Mhm.
Interesting.
Yeah. Well, guys, thank you for the
My
time.
pleasure. I mean,
Thank
these
you
are
for
always
having me.
good ones.
Yeah.
The podcasts that do the best, believe it or not, are the ones that involve divorce. These always do really, really well. The divorce ones do really, really well. The ones where we booze on the podcast seem to do really, really well, right? And then the ones that are basically like, and I say it, I'll say like, I don't have a crystal ball. Anything of me predicting something
Mhm.
it goes really good for views and really bad for comments. It's like, and I always preface it. I'm like, oh, no one really knows, but here's what I think.
Right.
But like, look at
Right.
this idiot.
It's
What-
my professional opinion.
Right.
Right.
That's all it is.
Yeah, I don't have a crystal ball, but again, the divorce ones, love them. Liz, I want you to come back on because not only do I want you to we drop off your clips, which I forgot to upload the one of you and Keith.
Yeah. Well,
You should meet with Keith because of your background
Who's Keith?
with your education. Keith Powell is a certified divorce financial planner. and he runs a networking group that is basically all about people that are going through divorce so that they can connect with professionals that have a little more expertise, not in just their specific line of work, but also can kind of white glove, handhold, cater to the divorce situation. So he was a guest on here.
Yeah.
Yeah. Yeah. So he was a guest on here with Jimmy, and they went through all of their stuff, and I have clips for him that I have to get to him, and we'll get this one out to you as well. But I'd love to get you on here individually as well, so we can talk a little bit more about just you.
So tell everybody how they can find you if they.
Yes, please.
Yeah, my website is lizwarrenaustin.com. Pretty easy. I'm the other Elizabeth Warren. I'm not running for Senate. I'm not running for president. People ask me that all the time. So lizwarrenaustin.com. You can find me there.
Perfect.
Awesome. Well, we'll put some stuff together, and we'll get you back on again.
Cool.
This is like going to the
Thanks,
gym.
Matt.
You can't just go once.
I can.